Hello friends, today I take up a new topic and the name of the topic is the basic structure of the Constitution of India. And this is an important innovation by the Supreme Court of India. We will discuss it in detail. My lesson plan includes introduction, historical background, elements of basic structure, recognition by other countries of the world, conclusion. These are the important points that will be covered under our topic, the basic structure of Indian Constitution. Friends, if you like my channel AJIS Academy Indore, please share and subscribe. This is free channel on YouTube and my Facebook page. So now let us start the proceedings. Introduction. You see that the principle of basic structure is an innovation by the Constitution, by the Supreme Court of India, and the tussle between the Supreme Court and Parliament continued for 20 years. This doctrine has been adopted by most of the countries of South and Southeast Asia and even some African countries. Basic structure principle postulates that the constitution of a sovereign state has certain special characteristics that cannot be erased by the legislature. In Keswanand Bharti versus State of Kerala, the Supreme Court, Justice H.R. Khanna, postulated that the Constitution of India has certain basic feature that cannot be altered or destroyed by Parliament. The doctrine thus formed the basis of the judicial review by Supreme Court and High Court, and it strikes down, judiciary strikes down any constitutional amendment which seeks to alter the basic structure of the Constitution. Friends, it is to be noted that the principle or the doctrine of basic structure has not been defined by the judiciary, and the basic feature is determined by the court that comes before it. So now you see that the Supreme Court has armed itself with vast powers. Now I switch over to another point, historical background. Friends, you see that since government of India, which was ruled by Congress party, and the objective of Congress party was to implement land reform policy, land tenancy act, zamindari system. It had been an important plank of Congress party during the freedom struggle. And so in 1951, Congress government abolished zamindari system. You might be knowing that during the British period there were three types of land revenue system: the permanent settlement that operated in the Bengal province, in which the present day Bangladesh, Eastern Bengal, West Bengal, Bihar, Odisha, and a part of Banaras These areas form part of permanent settlement. In the southern states, Rayatwari system prevailed, and in Punjab, Suba, Awadh and Agra Suba, Mahalwari system were operating. So once we became independent and a republic in 1951, the Congress party under its first Prime Minister Jawaharlal Nehru abolished Zamindari system and reformed Land Tenancy Act, and these reforms were put into a new schedule that is called Ninth Schedule. In the original constitution, there were only 8 schedules. Now, 9th schedule was also included in our constitution, under which all the reforms relating to tenancy and land ownership, these were kept under 9th schedule in order to ward off or to remove interference of judiciary. So you see that picked by this reforms, some of the important zamindars went to Supreme Court, and in the case called Sankri Prasad Singh Dev, the Supreme Court ruled that the power of Parliament to amend any part of the Constitution under Article 368, even the fundamental rights, and it has inherent power. So the judgment came in the wake of the first amendment of the Constitution, as I have already told you. So what we see, that in the Sankri Prasad case, Supreme Court ruled that the power of Parliament to amend the Constitution under Article 368 also includes power to amend fundamental rights under Part 3, and the judgment came in the wake of the first amendment of the Constitution, which was related to the Tenancy and Land Ownership Act. Now, you see that the word law in Article 13 includes only ordinary law and not constituent law. Thus, Parliament can abridge or take away any of the fundamental rights by enacting a constitutional amendment. Article 13 of the Constitution says law inconsistent with or in derogation of the fundamental rights. All laws in force in the territory of India immediately before the commencement of the Constitution, insofar as they are inconsistent with the provision of this part, shall, to the extent of such inconsistency, be void. The state shall not make any law which takes away or abridges the rights conferred by this act, and any law made in contravention of this clause shall, to the extent of the contravention, be void. Now, in Goloknath case, in 1967, the Supreme Court reversed its earlier judgment. The judgment delivered in the case of Sankri Prasad in 1952 and Sajjan Kumar in 1955. Sajjan Kumar. Now, Supreme Court held that Parliament cannot abridge or take away any fundamental rights. It means that it is beyond the power of Parliament to take away or abridge any fundamental that has been given under Part 3 of the Constitution. Now, according to Supreme Court, a Constitutional Amendment Act is also a law within the meaning of Article 13 and hence would be void for violating any of the fundamental rights. Now, Parliament reacted. What was the reaction of Parliament? It enacted 24th Amendment Act 1974 and amended Article 368 and 13 of our Constitution and asserted that Parliament has power to abridge or take away any of the fundamental rights under Article 368 and 13. Article 368, friends, you know that Article 368 is the amending article of our Constitution. Here is a provision as to how our Constitution can be amended. So you see that it has established a procedure as to how the amendment procedure can be made in our Constitution. Now you see that there are certain articles which has been kept outside the purview of Article 368. For example, alteration of boundaries. Alteration of boundaries of a state. Now Parliament has ample power, unlimited power to change the boundary of a state, to amalgamate to a state, to make one, to cede any part of a state to the foreign countries as per its treaty, as per the implementation of treaty. So, Article 1 to 4, which are related to the description of different states, union territories, acquired territories of India. So, any alteration or changes doesn't come under the purview of amendment, but under Article 368 there are two provisions that is of utmost importance, and these are those articles that affects central laws that can be amended by 2/3 majority of each house plus absolute majority of each house, and then it will be presented to the President of India, and once President sign over it, that bill becomes constitutional, bill becomes law. Now, you must understand that in matter relating to constitutional amendment bill, President has no power even for sending that bill for reconsideration. President will have to sign over the amendment bill passed by both houses of parliament with two-third majority present and voting, and with absolute majority of the total membership of the house. Now, those articles which also affect states, provinces. So you see that there is a different provision, and that is that apart from passing the constitutional amendment bill in both houses of parliament with two-third majority present and voting plus absolute majority of the membership of that house, with the ratification of half of the states of Indian Union. So you see that like the election of the President and Vice President of India, or GST, or changes in the power of Supreme Court and High Court, or Election Commission. So there are certain provisions in the Constitution which affect both central government and state government. And in that situation, whenever an amendment is brought before the parliament will have to pass that amendment bill in both houses of parliament with two-third majority present and voting and absolute membership of that house, and then ratification by half of the states of India, and that will be ratified by two-third majority of that legislative assembly. Now, reaction of Supreme Court. What was the reaction of Supreme Court? In Keswanand Bharti case 1973, Supreme Court overruled its judgment in Goloknath case, upheld the validity of 24th Amendment, and stated that Parliament is empowered to abridge or take away any of the fundamental rights, but it cannot destroy the basic feature of the Constitution. Friends, as you know that Srimati Indira Gandhi nationalized 14 banks, and the privy purse given to the erstwhile princes were taken away. Now both action of Congress party were invalidated by Supreme Court, while the contention of the government was that it is implementing the directive principles of a state policy, while Supreme Court took another view. And so it declared both the acts of government void, with the result that Srimati Gandhi dissolved Lok Sabha and asked fresh mandate from the people. And in 1971, Congress party came to power with two-third majority, and so within 1 year, the banks were nationalized and privy purse given to princes were also taken away. So you see that the Supreme Court applied this principle of basic structure in Indira Gandhi case in 1975, whereby the court invalidated the provision of 39th Amendment Act, which kept the election dispute involving a speaker and prime minister outside the jurisdiction of all courts. By the 39th Amendment, Srimati Gandhi precluded Prime Minister and a Speaker of Lok Sabha out of the purview of all courts of India. And so we see that in 1975, again court asserted its authority and said that no, it is wrong. Judicial review, the power of judicial review of judiciary cannot be taken away. The court said that this provision was beyond the amending power of Parliament as it affected the basic structure of the Constitution. So now you see that the doctrine of basic structure of the Constitution now started being applied by Supreme Court. Reaction of Parliament. Again, Parliament reacted. How? By 42nd Amendment 1976, the Parliament amended Article 368 and declared that there is no limitation on the constituent power of Parliament and no amendment can be questioned in any court on any ground, including that of contravention of any of the fundamental rights. So you see that the tussle between the Parliament and Supreme Court was going on. Now reaction of Supreme Court. Friends, as you know that in 1977, emergency was lifted and a new government was formed. At the center, Morarji Desai became the Prime Minister of Janata Party government, but it continued to function only for 2.5 years, and thereafter, because of bickerings among different constituents of Janata Party, fresh election was called in, and in 1980, Srimati Indira Gandhi again returned to power with thumping majority. So now in 1980, in the Minerva Mill case, Supreme Court asserted and invalidated the provision which excluded judicial review. It asserted that Parliament has limited power to amend the Constitution and that limited power cannot be converted into absolute power. It can change the provision, but it cannot alter or destroy the basic feature of the Constitution. This was the assertion of Supreme Court. Now, in Baman Rao case in 1981, the Supreme Court held the doctrine of basic structure would apply to all cases that has been decided on 24th April 1973 and thereafter. So you see that what is its implication? Friends, as you know that under the garb of 9th schedule, more than 282 laws have been put under 9th schedule to preclude judiciary from examining the intent of that law, the scope of that law, the constitutionality of that law. And so Supreme Court took the position that any amendment which has been affected since 24th April, the day of the judgment of Keswanand Bharati case, 24th April 1973, all amendment will have to undergo judicial review, whether it was kept under 9th schedule or not. So the umbrella of 9th schedule was taken away by Supreme Court in the case of Baman Rao in 1981. Now I switch over to another point. Elements of basic structure. Friends, at the outset I have told you that the doctrine of basic structure has not been defined by Supreme Court or High Court. It decides a particular case whether it comes under basic structure or not. So now Supreme Court has armed with unlimited power from various judgment we can summarize the following basic structure of the Constitution. For example, supremacy of the Constitution. You see the supremacy of the Constitution already postulated in Keswanand Bharati case. Separation of power between judiciary and executive and legislature, republic and democratic form of government, secular character of the Constitution, sovereignty and unity and integrity of our country. So you see that supremacy of the Constitution, sovereign, democratic, republican and secular nature of the Indian polity, separation of power between the legislature, the executive and judiciary, federal character of the Constitution, where the power of state and central government has been clearly defined under 7th schedule of our Constitution, unity and integrity of the nation, welfare state. In order to implement directive principle of state policy, judicial review, freedom and dignity of the individual, parliamentary form of government. And friends, as you know that what is parliamentary form of government? We have borrowed this concept from Britain. And what does this mean? It means that parliamentary government will have a prime minister at the head and a cabinet which will take decision, executive decision, and the president or the head of the state will be a nominal head, will represent the unity of the state. So I will discuss later on what are the basic features of the parliamentary form of government, and parliament, executive will be responsible to parliament and especially to lower house, I mean Lok Sabha in India, and the government will remain in power as long as it enjoys majority in the lower house, I mean Lok Sabha, and in between it is House of Commons. So parliamentary form of government, rule of law, that everybody is equal before law, and a state shall not deny equal protection of law to anybody. That has been enshrined in our Constitution under Article 14. harmony and balance between fundamental rights and directive principles of state policy. And so, friend, we see that in Minerva Mill case, Supreme Court delivered the judgment, and it said that whenever there is a question of implementing the directive principle of state policy under Article 39 B and C, and this means equitable distribution of the resources of the state among people, and restrictions or reduction of the concentration of wealth. These two important aim of directive principles of state policy, if they are implemented by Parliament, then Article 14 and 19 of fundamental rights will not come in between. So, Supreme Court changed its stance, its earlier stance. Now you see that it was aimed at to harmonize relation between fundamental rights and directive principles in order to establish a socialist state in India. Principles of equality, social justice, effective access to justice, power of Supreme Court under Article 32, 136, 131, 142, power of High Court under Article 226, 227, independence of judiciary, free and fair election. So you see that these are the important elements of directive principles of state policy. In S.R. Bomey case, Supreme Court opined that federalism, secularism, democracy, in unity and integrity of India, social justice, judicial reviews, these are the important ingredients of basic structure of our constitution. And again, in I.R. Coelho case, I.R. Coelho, the judgment was delivered in 2007, and by which Supreme Court opined that rule of law, separation of power, principles of fundamental rights, judicial review, principle of equality, all these are the ingredient of fundamental rights. So now, friends, I switch over to another point, and that is recognition by other countries of the world. Friends, you see that I have already told you that the doctrine of basic structure is an innovation by the Supreme Court of India in order to harmonize relation between judiciary and parliament and executive. And so this is a landmark judgment, and this judgment has been very much taken away or cited in different countries of South and Southeast Asia and even African countries. Now you see that this principle was adopted by the Supreme Court of Bangladesh, even Pakistan, Belize, Malaysia, Uganda, etc. So this doctrine has far-reaching impact upon the judicial activism in India. Now I switch over to conclusion. What is conclusion? The basic structure doctrine established a constitutional supremacy instead of parliamentary supremacy. Why I am telling this? Friends, as you know, that although we have borrowed this parliamentary form of government from Great Britain, but in our country, it is constitution which is supreme. Why? Because in Britain, where there is no written constitution, the British constitution evolved since 1215, the day of the Charter of Magna Carta, and thereafter it evolved in the present shape. Now, in our country, there is a written constitution. There is a clear-cut demarcation between the union government and provincial governments. So there is a strong judiciary to settle disputes between the center, union and the state, and between two states. And this is the original jurisdiction of our Supreme Court. So what you see, that in our country, apart from the constitutional supremacy, there is a element of federalism. There is a federal feature of our constitution where both central and state government coexist with their respective powers. Now, by this doctrine of basic structure, this constitutional supremacy was established by judiciary, particularly Supreme Court. So now the situation is that Parliament can't do anything. It will have to work under the 4 parameters of our Constitution. Now, by not defining the doctrine of basic structure and to decide what basic structure constitutes in every case, Supreme Court has armed itself with vast power to check parliamentary excess. Again, the doctrine harmonizes the power of parliament and judiciary. Friends, it may be a situation may come where a government in power enjoys absolute majority in Lok Sabha and Rajya Sabha, and it has government in more than half of the states of Indian Union. Then what will be the fate of the Constitution? Constitution will be amended abruptly to suit the interest of the particular political party in power, both at center and at states with absolute majorities. So you see, here the base principle of basic structure will come to protect our Constitution. So in spite of the absolute majority in both houses of Parliament or in more than half of the states, no political party or government can dare to change or destroy the basic structure of our Constitution. And judiciary will come to play as a check upon the unlimited power of executive. So friends, now I am winding up this discussion. If you like my channel, please share and subscribe. This is free channel AJIS Academy Indore. Just type on YouTube and my Facebook page and you will have numerous videos covering different topics. Thank you very much.